And we're going to go ahead and start this meeting.
All right, calling into order.
Calling it to order.
Okay. It is slightly after 10 o'clock on October 5th of 2022. My name is Chauncey Molding, I'm the Jefferson County Attorney. Pursuant to informal resolution 22FC:0049, this is in regards to the formal complaint to the Iowa Public Information Board by Tom Drish against the Jefferson County Board of Supervisors. Pursuant to an informal resolution of that proceeding, one of the clauses is that a training be conducted on Iowa's open meetings record laws. I have been presented a PowerPoint presentation by the Public Information Board, which I've made some minor modifications to, but should serve as the requisite training documentation. So essentially, I've run through this. This is a pretty brief walkthrough of the obligations and requirements of public bodies with regards to both open meetings and open records. So unless there's any kind of preamble statements that want to be made, I'm just going to jump into it. It should take half hour or so. Okay. Open meetings are covered under Chapter 21 of the Iowa Code. Open records are covered under Chapter 22. Both of these chapters together formulate what is colloquially referred to as Iowa's sunshine laws, or our open meeting and records requirements. This chapter defines what a government body is. It's certainly fair to say that the Board of Supervisors constitute a government body. Public notice and the requirements for having a meeting, what is required to go into closed session. And Susie, if you don't want to take notes, I can provide you with a written version of these
Okay.
slides.
Okay.
Often it saves me a lot of time to,
I just do this stuff.
Fair enough. 21 also covers the rules of how to conduct meetings, as well as what would constitute a violation of such chapter. So this is just going to kind of run through it piece by piece. Section 21.1, quote, the law seeks to assure that the basis and rationale of government decisions, as well as those decisions by themselves, are easily accessible to the people. The general concept, our government is, by and for the people, and we don't do things in secret except for very specified purposes. Ambiguity should be resolved in favor of openness. So when there's any doubt, we keep the meeting open. 21.2 sub 2, a gathering it defines what a meeting is constituted by. A gathering in person or by electronic means of a majority of the members of a government body. Essentially, with a board constituting 3 people, any meeting of 2 individuals or more doing public business would constitute a meeting. It can be formal or informal if there is deliberation or action. So deliberation basically means having a conversation about public business. Public business under your purview. You guys can talk about what's going on in Washington all you want. But further definition of a meeting, 21.2 sub 2, does not include gatherings of members of a government body for ministerial or social reasons. You can go to a birthday party, you just can't talk about public business at that party. No intent to avoid the purposes of this chapter either. So there are no exclusions for cute workarounds to the rules. The rules are the rules. Further definition, a board, council, commission, or government body created by Iowa statutes or by executive order. This is just further defining government bodies. We don't need to go into that. It's very clear that the Board of Supervisors are a government body. That includes advisory boards, task force. I think several members of this board may also be members of other government bodies for the purposes of Chapter 21. City councils, council committees, utility boards, library boards, parks and recs, planning and zoning, boards of adjustment, airport commissions, board of supervisors. Public notice requirements of 21.4. This is critical, and we deal with this every single week. Meetings are preceded by public notice. For our purposes, our public notice gets posted in a public space here in the courthouse. Posted in a prominent place at least 24 hours prior to a meeting provided to media who have requested notice. I'm not clear, Abby, does the radio station request notice?
Yep,
Okay.
they're on the list.
Yeah, we've got a list of people we provide notice to, right?
Yep.
Time, date, and place with the tentative agenda. Meetings can be held without 24-hour notice with, quote, good cause. And if we do have a meeting with very brief notice, we need to state why the notice can't be provided in the meeting and in the minutes. 21.3, meetings shall be held in open session unless closed sessions that are expressly, or unless closed sessions are expressly permitted by law. And those reasons for being able to close are very specific, and we'll go into that later. Meetings must be held in a place and time reasonably accessible to the public, unless for good cause, such as place and time is not possible. So, I mean, for us, we typically have it here. Minutes of meetings, sections 21.3, 372.13. This is specifically, we're mostly focused on 21.3 here. Governmental bodies are required to take detailed minutes of all meetings, must show the date, time, and place, members present, and any action taken. Must show the results of each vote taken. Minutes are public records and open to public inspection, and have to be published within 15 days for city council purposes. 21.5 allows for closed session for specific purposes, and there's numerous enumerated purposes that we won't go into all of them. There are a few that get referenced by this training material. To evaluate professional competency of an individual whose appointment, hiring, performance, or discharge is being considered when necessary to prevent needless or irreparable injury to that individual's reputation, and that individual requests a closed session. We talk about this a lot, and this is a very critical one. However, it's important to note that the purpose for that closed session is to protect the reputation of the individual being evaluated. So it is at that person's request. If an employee of the board, doesn't want it to be in closed session, the board can't bring it into closed session without that person's request. To discuss litigation strategy with counsel. If we were in the process of litigation, or if litigation was being anticipated, we can certainly discuss that behind closed doors. To purchase real estate, I believe that is one of the reasons why we went into closed session on the date referencing this informal resolution. To avoid disclosure of specific law enforcement matters. Closed sessions have to be on the agenda. The vote to go into closed session has to be in open session. We need to also put on the agenda the specific reason, the code section, why we would be going into closed session. Each one of those specific clauses carries some code designation. We certainly don't need to get too detailed about litigation if that's necessary. Every action in this board needs to be by 2 of the 3 members. I suppose if we're trying to go into closed session with only 2 members present, it needs to be unanimous. You can ask me if it's lawful to go into closed session for that purpose, and you can rely. I would hope to say that your advice of counsel would be accurate. If for one reason or another a court determines that I gave you inaccurate information as to going into closed session, the board wouldn't be held responsible for that. But I trust that I'll be giving you good advice on those matters. Meeting minutes can include the attorney's oral or written opinion that it is lawful. If your attorney states, somebody from my office states you probably shouldn't go into closed session, you can still go into closed session, but I wouldn't advise it. Detailed minutes and audio recording items must be sealed and can be opened by court order or potentially by state ombudsman until case cause for disclosure has ceased. For instance, if we're discussing the purchase of real property, once that deal is done, there's no purpose for having the closed session.
Right, and all of those minutes for the 16 minutes meetings that we did in closed session are now open for people to read.
Good, okay. When in closed session, we can only discuss the matters that we are closed for. We're not supposed to talk publicly. The people in this room aren't supposed to talk publicly about matters discussed in closed session. Final action cannot be taken during closed session. It can be discussed, but all votes have to be open. No secret votes. Government body can determine who attends a closed session. It's completely appropriate to clear a room of individuals that are not don't have a purposeful cause for being in the room. Section 21.8 about electronic Zoom meetings or electronic participation. Meetings can be conducted by electronic means. If meeting in person is impossible or impractical, notice must be provided. Public access to the conversation is provided. Meeting places where the communication originates or where public access is provided. For our intents and purposes, it's always basically here. That's why we've got the Zoom set up. Minutes are also kept, and statement or explanation why a meeting in person was impossible or impractical. Are all of our meetings still published on Zoom?
Yes.
Okay.
Yeah.
21.7, nothing in this chapter is to prevent governmental body from making and enforcing reasonable rules for the conduct of its meetings. We still have home rule. If you guys want to specify certain parameters for having your meetings, it's completely up to you to do that, but needs to be open, and we need to just err on the side of openness. These rules would be to assure meetings are orderly, free from interference or interruption by spectators. I saw a lot of videos of Zoom, I think it was called Zoom bombing during the pandemic, where people would come in and essentially blast audio or whatever it is. That you don't have to put up with that. None of these things should prevent you from having an orderly meeting. It's just the public needs to be able to observe. Meeting rules of conduct, you set the agenda, discussion, public comments, decorum, enforcement. Those are examples of things that you guys can set rules about, right? I think we've had previous discussion about public comments. Doesn't have to be a public debate. It's the time for people to make theirs known. 21.6, any aggrieved person, taxpayer, citizen, or the attorney general or county attorney can seek a judicial enforcement of chapter 21 upon a finding of a violation. These are the consequences for violation of 21. On a violation of a court shall assess each member of the body who participated in the violation damages between $100 and $500 for a first offense. Shall assess each member of the body who knowingly participated in violation damages between $1,000 and $2,500. These are shall. Upon a finding of a violation, if this was to be litigated, the court shall order payment of costs and attorney's fees. Shall order payment of by the violating members. Will void the action taken if the suit is brought within 6 months and the court makes certain findings. Order a member removed from office if it's the second violation. Essentially, continuous violations of open meetings rules or subsequent violations can result in removal by them, but all these would be decisions by the court. This is a judicial proceeding. Damages will not be assessed if a member voted against the closed session, believes the facts indicating compliance with the law, relied on a court decision, attorney general's opinion, opinion from the Iowa Public Information Board, or opinion from the government body's attorney, and the attorney's opinion must be written or, if oral, included in the minutes. Alternative means to enforce the open meetings and open record laws are complaints made to the IPIB can be handled informally. Information assistance or mediation. There may be a formal investigation of a complaint, and if probable cause is found, a contested case may be prosecuted. So essentially, if there is an inability to resolve these matters informally, they can be resolved formally being in front of the district court. IPIB board may issue orders with the force of law determining whether there has been a law violation, require compliance, impose civil penalties, or other remedies. All right, any questions on chapter 21, open meetings? All right, we're moving on to open records. Open records, less of you guys don't deal with open records requests on a weekly basis. Open meeting requests, open meetings are always dealt with. Chapter 22, this is what we're going to cover. 22.1, all government bodies, officials, and employees are covered by chapter 22. Each body must designate a, quote, lawful custodian for its records and must publicly announce who holds that responsibility. Does the board hold records? Is there, the auditor's office is the secretary for the board, so I believe
they're the keepers of the records.
So one thing, and it's not in the presentation, but it's really kind of critical that Open records requests must be made to the custodian of records. So often I'll get requests for example, if somebody's requesting body camera footage from an incident at the police department. Well, they can request that from my office. I can direct them to the custodian of those records with the city, but because that request is still directed at me, I can't help them with that. You have to send it to the person who is the custodian of those records. So for the Board of Supervisors purposes, if you were requested records, if people are asking for records from you, I would direct them to the auditor's office. The term, quote, record includes documents, tape, other information stored or preserved in a medium of or belonging to a government body. It includes electronic communications such as emails, websites, social media, or blogs. We conduct our government affairs in an open manner, but it should be noted that, when we send emails on a government email system, those are likely to be constituted as open records and can be accessible to the public if requested. Anyone can examine, photocopy, photograph a public record without charge while the public record is in the physical possession of the custodian. Pretty clear. 22.4, during the customary office hours, a lawful custodian, we're open to the public from 8 to 4:30, right? So that's irrelevant here. 22.8, most requests are routine and will be handled immediately if possible. Good faith delay is allowed. We should respond to requests as rapidly as practicable. Should not exceed 20 calendar days. There are certainly exceptions to that. If somebody's asking for voluminous records, we can take some time. It's also completely appropriate to redact or remove confidential information, right? So nobody has a right to other people's social security numbers, or I'm sure there's a lot of data held by the auditor's office with relation to elections that is completely not public record. So all those exceptions we'll get to in a minute, but as a general rule, things are open unless there's a reason to close. Record custodians should work with requesters to ensure that the correct records are released in as timely a manner as possible. Records requests do not have to be made in person. Officials shall fulfill requests made in writing, by telephone, or by electronic means. They don't have to send it. Doesn't have to be a formal letter with a letterhead for it to be constituted a open records request. Examination and copying shall be done under the supervision of the records custodian. Should not relinquish control of the records. Preserving the records is critical, right? We don't want to open them up to modification or tampering. Lawful custodian shall adopt reasonable rules to safeguard these records. Custodian shall provide a suitable place for the examination of records or move to a separate location if necessary. Lawful custodian may charge a reasonable fee. That if we charge fees, we have to charge fees to everybody. Just because we find somebody might find a request annoying doesn't mean that we can charge that person and not charge somebody else who had made a more simple request. Fulfillment of a request may be made contingent upon payment of a fee, and estimated expenses shall be communicated to the requester. If it's going to take 10 hours to get the public record request, particularly if redaction is necessary, it's completely appropriate to request payment up front. Can't exceed the actual costs. I certainly don't think it's necessary to go through all the records, the exclusions contained in 22.7. There's 69 types. Other sections of the state code and federal law also contain provisions of confidentiality. Just because 22.7 does not specifically enumerate a reason for keeping a record confidential doesn't mean that it's not confidential. A big one that I would consider would be HIPAA, right? HIPAA is not specifically delineated in 22.7. However, it's quite often a reason for not releasing records. Public records law allows the release of confidential information when, quote, ordered by a court, by the lawful custodian of the records, or by another person duly authorized to release such information. All right, this is a list of the most common confidential records. Work product of an attorney related to litigation by or against a public body. Peace officers investigate reports except for the date, time, and specific location and immediate facts and circumstances surrounding crime or incident. We've interpreted this clause as being that the computer-aided dispatch records from dispatch are public records, so you can find out what time an incident happened, where it happened, and who was involved. However, the actual police reports that are generated by the responding officer are deemed confidential during the investigation of the case. Appraisal information concerning the sale or purchase of property for public purposes prior to the announcement of the project. Certain personal information, age, race, sex, address, social security number, telephone numbers, personal information of government employees. Information submitted, which is not required by law and submitted from somebody outside government, and a lawful custodian could reasonably believe that these persons would be discouraged from submitting. That's probably a case-by-case basis that should be taken very seriously. If somebody is asking, hey, who's been emailing you about this? We want to be very careful about disclosing that if that could subject them to harassment. 22.7 sub 11, consider public information the name and detailed information regarding compensation of an employee, including any written agreement about terms of employment, employment dates, positions held. So all these things are not confidential. Employment dates, positions held, educational background, and previous employment, the fact that any employee was discharged as a result of a disciplinary action, records relating to the discharge of an employee, including those that resigned in lieu of termination or were demoted, and documented reasons for such decisions. After a legal dispute involving government entity is resolved, on request, a summary must be prepared that indicates the identity of the parties involved, the nature of the dispute, and the terms of the settlement. This summary and settlement agreement are public record. Public records of the city, this is not a relation to the county. Some records remain permanently valuable due to their content as required by state or federal law, such as things that are held by the recorder's office. Many records are of no further use once the matter has been transacted and routine audit logs and administrative uses have been completed. There's no reason that we need to hold on to, payment records from the 1970s or whatever it is. There's certainly a cause to develop a data retention policy. 22.10, this is in relation to enforcement. Court can issue an injunction ordering a government body to comply, assess damages between $100 and $500, or order payment of costs and attorney's fees if this goes to litigation. Member of a government body, similar fines to the open meetings rules. Participating in a violation of open records can amount to damages between $1,000 and $2,500. 22.10, not knowing the law is not an excuse. Damages will not be assessed for officers who voted against the violation. Government officials who rely on advice from the IPIB are also protected. This is the contact information for the IPIB, and that constitutes the training materials for chapter 21 and 22. Any questions? Yes, sir.
All right. So.
What else are we doing?
Well, that I believe on the agenda was the training session. There is a resolution for 21 FC 0049 that needs to be essentially read in and voted on and included with the minutes to be presented to Des Moines. That is the resolution.
We got copies of this.
You have a copy of that?
Yeah.
Okay.
I think you sent it out.
Yeah.
Okay.
Okay. And so that should take place in an open meeting at another time.
Okay,
Cool.
very good.